Anyway, I'll start a bit as Vicky did to point out there's been as everyone will be aware, a new interest in writing about women and law, which was prompted by second and the subsequent waves of feminism, but in particular by the centenary of women's admission to the legal profession in the UK, which was in 1919. So the centenary was in 2019, and there are a number of projects, some of which I was involved in, to commemorate this. And obviously, this is a very welcome revision in a very traditional discipline. And when I say traditional discipline, law is a very traditional discipline, but legal history particularly so. What we found, however, and what we've seen and what I'm still seeing in projects I'm still involved in, is a sort of misunderstanding, I suppose, amongst those who want to write feminist legal history, either about what is feminist or indeed what is historical, what is law. And one of the problems we found, particularly with the legal scholars, rather more, I think, than the historians, is that legal scholars find it very difficult to go beyond legal sources. A lot of legal historians think that legal history is simply tracing through the judgments or the reported cases or the statutory interventions, and are completely unaware of the really quite substantial amount of historical and feminist historical work on the periods that they're dealing with, because, of course, feminist history started a bit much earlier, I think, than feminist law. But on the other hand, we do find sometimes, and certainly this was the case with me, because I started out as a historian. My PhD was in history. And I cringe, actually, at some of the things that I say in that thesis, where I've obviously misunderstood. I thought the attainment of some kind of statute benefiting law was like it. That was it. Everything was fine. And of course, as feminist legal historians know, often the statute is the start of a new story. Next, please. So I said that law is very traditional, legal history particularly so. Traditional legal histories ignore women. They simply do, or they pop in and out. You learn when they get the vote or when they're admitted to the profession, and off they go again. You don't see them again. And this is also true of biography, and particularly biographies of great men. Even historical biographies. Now, as I said, feminist history's been around a lot longer than feminist legal studies. But on the other hand, we still do see biographies of great men, which are untouched by any kind of feminist input, which I hope I'm going to make clear in this presentation. It's partly, I think, because a lot of biography and legal biography focuses on public lives, and legal biography often on thought, on ideas, leaving out entirely the private life, almost to the point of thinking, and this has been argued to me, that the private life of great men is irrelevant to their achievements. What this means is if you only focus on public lives, first of all, you're leaving out a lot of women who often don't have public lives. You're only going to include those who made their mark in public life. But crucially, you're leaving out the private side of men's lives. It's never left out for women. If you read something about women, there's always got to be some reason why they are in public life, and the private's got to be explained away. So, for example, she could become a judge because her husband helped with the housework or children or whatever, or they had a nanny. There's always got to be some explanation there. Never for men. Their public achievements just, are natural. Next, please. But the other problem, I think, for lawyers and legal historians is that gender-free legal history is presented as neutral, objective, the complete approach. That's what you need to know. It's what our students think they need to know, right? The story of law. And if you present feminist approaches, they're immediately seen as partisan, political, and of course, when it comes to legal studies, optional. You can pop in a bit of feminism if you want. You can put some women into the story, but you don't have to. That's not the real story. And the explanations for that, of course, feminists have long known for hundreds of years. It's because men have controlled the knowledge that's passed down. They controlled the education, the publishing houses, the curriculum on the LLB, and up till recently on the history degree as well. And of course, they present a history that serves the interests of men, presents them in a good light, and excludes women, which serves to buy off radicalism. And of course, and this with reference to earlier presentations, it's also white men, it's also privileged men, it's ruling class men. So it buys off all those other groups and any sorts of movements like the women's movements or the civil rights movement. And it serves to disempower critics because, as the civil rights movement discovered, Black people had no heritage and therefore had no models of resistance, but also had to keep reinventing the wheel. And that's certainly been true for women as well. And then I've got this little quote from Catherine McKinnon: "It's thought possible to know a subject while maintaining illiteracy on questions of gender." That's how optional it is. Next, please. Now, looking at a few different forms of legal history, legal biography, for example, or stories of legal history, which are perhaps tracing movements. There's often a heroine who's identified, or if she may be the subject of the biography. And what we see in quite a lot of accounts still today is that she's presented as a heroine. It's something that Erica Rackley and I have written about, and many of us have tackled, Caroline as well. The problem is, if you pick out someone who you think, yeah, she's the woman who did it all, and she's a real role model for all of us, it does encourage over familiarity with her. The number of historical studies where all the men are called by their surnames and all the women by their first names. Have you noticed that? And I've heard a number of legal writers say, "Oh, you know, I got to know her so well. I felt I really knew her. I knew how she would think." One of possibly of the dangers of I don't know, it's actually putting into someone else your own thoughts, often anachronistic ideas, because a lot of legal scholars don't have this grounding in the history of the period. And so they think that their heroines necessarily think like them. It sets up role models who often, in the case of, say, early women lawyers or judges or something, will be rich, white, well-connected women who probably haven't had an easy time, but are hardly going to serve as good role models for most of our students, who are usually not rich, white, and well-connected. And the heroine narrative, the idea of setting up one woman as having accomplished everything, serves patriarchal scholarship, since it portrays women as individuals who achieved their goal through their personal qualities, and not, of course, as we know, through being part of larger movements with lots of people involved, men and women, all pushing, and this one person perhaps taking the lead or being pushed to the front, sometimes not even voluntarily. And these sorts of accounts, if you win through your own grit and determination, will diminish the obstacles, and particularly the male opposition that these women faced. And in every account that we have come across in the work that we've done and our colleagues have done, there's been a lot of male opposition to the promotion of women in any kind of legal sphere or political sphere. So the problem then with heroine narratives is that girls are told they can do it too, and then they're doubly disempowered when they get into the position of tackling it, because they don't have the advantages of these women in history, and they're unprepared for the reality of the male opposition. Next, please. The other thing that we find in some of these accounts that have appeared in recent years is the appeal of the progress narrative. And this is called different things to different people. When I was a history student, that was called Whig history. But it's very much this idea that things are getting better and better and we're moving towards the ideal. And you find it time and time again in women's legal history, where at every point of any reform, you'll be told women are equal now. And they've been being told that for more than 100 years. Women are equal now. We have equality. Well, we know we don't have it even now. It is the classic foundation of doctrinal legal training, since we follow the doctrine of precedent. And so we do look at how the law develops through court decisions or through statute, which is meant to reform the law. But this kind of idea that things just get better and better serves patriarchal scholarship, because it does suggest that reform will come, whatever happens, whatever you do, at the hands of lawmakers who are fundamentally benevolent, or we often see the phrase social attitudes changed. And of course, the courts respond to these changed social attitudes. No one ever says why they changed. They don't refer to the movements that might have gone on for decades or centuries for equality. And of course, they give the idea that there's no point in campaigning because, the law will change. We're nearly there. There's the trickle up. There's all those sorts of theories. Feminists can be marginalized. They can be made to seem extreme or irrelevant. Next, please. What is feminism? I just ask this, it's such a basic question, but just because I think feminist legal studies are so optional that many of our students never come across any of this, and I think many scholars never think of it. Obviously, it's a theory and a politics about the relationship of men to women. And that's the important thing. It isn't just about women's history. It is about this relationship, a relationship of power, in which, of course, men have power, more power than women, but also power over women. And obviously, there are many different feminist theories. Some liberal theories would just say we're unequal and we need to work on that. Radical feminists would say we're oppressed. Capitalism may be blamed more, or patriarchy, which is, the institutions being in the hands of men. Feminism explores the mechanisms of control in law, different legal treatment under gender-neutral laws, and that's really very common. Gender-neutral laws often affect men and women differently, but are presented as equal. Obviously, very important, women's different access to money and property, the way we're brought up as men and women, the physical control of women by men, and as Caroline mentioned, the silencing of our past, our history, our complaints. And feminism then devises ways to challenge and overcome these. That's why feminist legal history, it's one of the reasons why feminist legal history is so important. Next, please. Okay, and just to make a point that it's different from women's legal history. Women's legal history adds women into the story. Okay, we've left out the women. We're going to pop them in. Okay, here were some women judges, lawyers, but it doesn't change the story. Feminist legal history changes the story. It writes a different story. It writes a more accurate story. Well, I know there's a problem with accurate. Okay, but I think it is more accurate, and it's certainly more reliable to put in a feminist analysis, because you're not just putting women into it, you're looking at their relationship to men. Next, please. Okay, right. What feminist scholarship does? Okay. First, the most important finding, I think, that we've had in all the projects we've been involved in is that heroines don't succeed through their efforts alone. There will always be a network of supporters and feminist activists. And of course, in the 19th century, it had to have male support because there weren't any women lawmakers, either in the courts or in Parliament. That's really important, that really so many accounts of legal history leave out the activism. I'm involved in a project at the moment where we've asked for abstracts to be sent, and we've had quite a lot looking at the history of, I don't know, gay rights or discrimination or something, all of which show changes in the law, incremental changes, but never look at how these came about, why they came about. So as the Women's Legal Landmarks Project showed, the women's history is a tale of progressive reform, usually fought for by feminists. And the other part of the story is it's nearly always limited, curtailed, and reacted against by the male establishment. And that's why in the Women's Legal Landmarks Project, which is a project I undertook with Erica Rackley, and in the second volume with Mari Takayanagi, we always asked not just what happened and how did it happen, but why and what happened next. And in every case, what happened next wasn't quite what the feminists wanted. It was interpreted in a more restricted way. There was another statute passed, or look at abortion rights, for example, in America, where something that we thought had been won in perpetuity was taken away. Now, feminism's been written out of legal history, and we're only now discovering the size and breadth of feminist activism in periods long thought to be without any feminism at all. Now, the first wave of feminism, as it was called, the 19th century, that's pretty well documented. The second wave since 1970 as well. But the interwar period, legal historians are only just getting into that. And the period just after the war, the 50s, that's what I'd like to challenge next, because the 50s are always portrayed as a really awful time for women. And yet, there was feminist activism. There were things going on. Next. Okay, so how does feminist legal history accomplish this? It asks the woman question, which is what historians have done for decades. How does this law affect women? Where are the women? Who is your audience? Who is the creator? And so on. It includes women's stories. It relocates men in the narrative. This isn't just about women. What are the men doing, thinking, saying? It establishes women as agents, not just as subjects of law and law reform. They're actually working with law. It avoids heroine narratives, and it challenges the tale of steady and inevitable progress. Next, please. Okay, so women are relevant in every area. Lots of people think, okay, yeah, but I don't do that. I do biography of a great man. Okay, I do histories of the legal profession. Now, histories of the legal profession often start with men in the 19th century and then women after 1919. But in fact, women were active in the legal profession before then. They just weren't qualified lawyers, but they were certainly doing law at the time. Similarly, biographies of great legal men ignore their private lives, but these men may only have achieved what they did because women were excluded. They had no competition from them, right? Women supported their personal lives. Men had no domestic responsibilities. And let's not forget that, and that should be there in the narrative. And again, if women weren't present, we need to ask why. You know, don't just ignore the fact that women weren't there in the 19th century in the legal professions. We need to say why. Why were they excluded? What were the mechanisms? And they were many and devious to keep women out of law. There wasn't anything actually banning them. It was just what the courts and the judges in the courts wanted. And then, does any given legal provision, however gender neutral, affect men and women differently? Are women's voices heard, their circumstances noted? Next, please. Challenging the agenda. Oh yeah, I'm ending with this quote that Erica probably wrote, actually, not me. But I thought it was a nice little piece of legal rhetoric. As long as feminist legal history is ghettoized and its content not incorporated into mainstream historical accounts, as long as the legal curriculum and textbooks ignore history generally, as they do because they're mostly about the law now, or harness it only in the service of the status quo, in other words, by saying, we have this lovely law here because it was terrible in the past and look how the courts have responded, okay? As long as everything a woman does is regarded as less important than the actions of men or entirely unimportant, then the knowledge and understandings that have been uncovered, publicised and become visible in one generation can and will disappear before the next comes along. Next, please. there are the references. And there are other things, of course, the Women's Legal Landmarks projects and so on. But anyone who wants to follow up these pieces of writing, I think, would be interesting. Thanks very much.